Greetings. I'm going to be talking today about therapeutic jurisprudence and the coronavirus. Let me begin just by saying that jurisprudence generally involves the study of questions about what is law and what is justice. It used to be that people had really definite answers to those questions, but by the time we get to the 21st century, we realize that there is no one perfect answer to either of those questions. The 21st century has also brought along with it new insights about what we mean by law, what we mean by justice. And therapeutic jurisprudence is a good example precisely of that. Therapeutic jurisprudence recognizes that law does not exist in a vacuum. That whenever we talk about law, it involves not only what is written in a text, but also the actual effect that law has on individuals and the way in which that effect on individuals can affect our development of the law itself. And so that's why therapeutic jurisprudence fits particularly into the context of the problems that we're dealing with today. There are a variety of ways in which we can understand that relationship between law and our well-being, both physical and emotional. One of them is illustrated simply by direct advocacy. Your client wants an advocate, and even a client who loses a case is going to feel better if they know they have been represented well and represented aggressively. That's a form of therapeutic jurisprudence. Other forms that have developed particularly in recent years involve things like mediation. Rather than fighting in a dispute, bringing parties together and resolve them comfortably. If any of you have had Professor Elrod in your classes in family law, I'm sure she's talked about collaborative law, ways in which lawyers and their clients come together, recognizing that when you're dealing with family law in particular, you're dealing not only with resolution of a particular dispute, but you're talking about ongoing relationships. And it's much better to collaborate rather than fight within those contexts. That development of collaborative law is another illustration of therapeutic jurisprudence. In fact, there are many ways in which our courts in recent years have developed those kinds of alternatives. Many of you may have heard about such things as mental health courts, a recognition that many of the people who were picked up by police officers because they're engaging in inappropriate or even criminal behavior are doing so not because they are criminals by the traditional definition of that word, but because they have mental health problems. And so we have mental health courts, where the judges take that into account and decide not whether or not a person should be convicted and how much time they should spend in prison, but how they should be treated and how they might best recover. Drug courts do the same thing, so that somebody who is found simply in possession of an illegal drug, instead of again facing the criminal justice process, might instead be diverted, appear before a judge who is particularly aiming towards providing the appropriate treatment. Veterans courts, dealing with people with PTSD. These are all indications of the way in which therapeutic jurisprudence has in turn made an impact on the law that we understand today. And how might therapeutic jurisprudence affect what we're dealing with in terms of COVID-19, the coronavirus? There are lots of ways in which we have seen it already illustrated around the world. For example, when the Ohio governor said, "I'm not going to pay attention to what the courts say, I'm going to postpone the primaries in the state of Ohio." That was an example of a person in a position of responsibility saying, there's more to the law than simply what is written in a text, and I'm going to exercise emergency powers and do something that's different. It is at some level an illustration of therapeutic jurisprudence, ways in which all lawyers treat their clients differently at times like this. Going to a client who is, for example, no longer having a job and needing to get special assistance, the tenants, the debtors, the individuals who simply can't meet their immediate needs. They won't necessarily be held closely to the specific text of law, but rather settlements and efforts to address their needs can be dealt with behind the law and in ways that provide a true resolution to the problems that they face given their emotional state, given their emotional needs brought along by the problems that we're facing. We should almost understand that what I've just been talking about in terms of therapeutic jurisprudence really lies at the core of our responsibilities as lawyers generally. Good lawyers are the individuals who understand not just the analytical problems that are entailed in interpreting a text, but also the specific needs of their client and the specific outlook or desires of the person on the other side, finding ways to resolve those problems. Now, I don't mean by this to suggest that we should all become psychologists or psychiatrists. Quite the contrary. What I do want us to understand is that we have responsibilities as lawyers to go beyond the written text of the law and to meet the needs as we perceive them of our clients. It's called empathy at one level. And empathy is something that I think all lawyers should embrace and should understand. Understanding therapeutic jurisprudence should also do something beyond that in terms of expanding our understanding of the law generally, and in particular, our understanding of what's really meant by the concept of justice. So that's what makes therapeutic jurisprudence particularly appropriate as something for us to understand in these troubled days. Thank you.